Okay, so this is understanding Islamic law, the final part or the second part, or as we did the understanding Islamic law, that was sources and all of that. So that's the continuation. So previously we had already discussed some topics and some subtopics about the overview of understanding of Islamic law and the origins of Islamic law, the pre-Islamic Arabia, the emergence of Islam. Then we understood that there are sources, which is like primary sources, secondary sources. So we had like the Quran, the Hadith, and like the secondary sources. And then we had Ijma and Qiyas. That's Ijma is a consensus, Qiyas is the analogical reasoning, and we further went into other sources as well. Then we understood that there was a compilation of the Quran. Moreover, the evolution of Islamic period, the Islamic law, sorry, was from like the early period, the formative period, the classical, the modern. This is something that we will be covering today. Um, Keep in mind that this video will be after we're done with this video, you'll be able to attempt the complete section A of Islamic law module. So if you remember, I did mention in my first, the introduction of Islamic law, that you need to attempt 4 questions, right? So there is section A and section B. So section A is the first 3 topics, and that's literally what we covered in the last video, and some of it we will be covering today. So the second video, this video. And after we're done with this part, you'll be able to cover like attempt 2 questions, and that means do half of your paper, and that's complete your section A. So the last video and this video, the section A is completely done for your module guide. So this video completes that part. First, we understand the influences, I guess. Yeah, okay. So, influence of other laws and Islamic laws, and overview of schools of Islamic jurisprudence. So, yes, so we had Roman and Persian, and the understanding is that Islamic jurisprudence did not fall from the sky. And that's me saying it metaphorically, because you need to understand that there was already some sort of jurisprudence, some sort of law, some sort of practice, some whatever the customs, practice, laws were at that time, that of course did influence the Islamic laws that were made, right? So how those influences came about, we'll be discussing them shortly. Okay, so we have the slide as pre-Islamic Arabian custom influenced the law of Sunni schools, particularly relating to succession on death and the idea of male dominant society. That's the patriarchy, right? So, which is very true. So, um, we say the pre-Islamic Arabian custom because that's the Arabia, right? So this was a period of Jahiliyyah, the age of ignorance, the period of ignorance before the coming of Islam. Is particularly strong in the law, right? Of the Sunni schools relating to succession of on death. Okay, so with this, you need to also understand that there was like an obligatory dower. The bride. Okay, so I will actually clarify this a bit. That is, there's a difference between dower and mahar. Mahar is the price that the husband pays to the bride. It's not dower, right? Dower and the dowry is what the bride prices, what the female, what the wife pays to the husband's family, what the parents of the wife used to pay to the husband's family, to the husband. That's dower, that's dowry. That was the obligatory dower that was abolished, banned, and told in the Quran that there will be no bride price, right? So to the husband. So, okay, let me just clarify this. What bride price means? It's the price that the parents of the female used to pay to the husband to get married. Now in the Quran, it is hak mahar. Hak mahar is the price that the bride receives when she marries the husband. It is as a gift to the wife. So there are very strict instructions for the mahar, which is that give the mahar of the wife at least 50% when you're like doing the nikah. So, and the idea that you need to give her the mahar as soon as possible. So that's the mahar, right? So this was so the idea of the exchange of monetary compensation in a nikah, in a marriage. Yes, it has been, taken from, traced back from the idea of bride price, which was a custom of pre-Islamic Arabia. That was, that. Then we have the Roman Byzantine, the law of Anatolia. So, for example, the principles of civil contracts were absorbed. The administration of bazaars, markets was modeled on the Roman law because the influence of Roman Byzantine, the Anatolia was more of the contractual business and markets and that nature, right? Then we have Sassanians of rulers of Persia. So concept of equality in marriage were adopted from here, particularly by the Hanafi school of law, the Hanafi school of thought, sorry, whose origins were in the garrison city of Kufa, which was located close to the boundaries with these empire. So the Hanafi took in the concepts of equality in marriage. Okay. Yes. Now, this slide is overview of School of Islamic Jurisprudence. Mazhabs are school of Islamic jurisprudence that develop over time. Yes. Um, Mazhab as a term is religion, right? And mazhabs in this context is that there are several aspects, several schools of Islam as well. So we have the schools of the Sunni schools that includes the Hanafi, Shafi, Maliki, and Hanbali. Then we have the Shia schools, that is the Isna Ashari, Ismaili, Zedi. These are the prominent ones, right? So the schools, I'd say, and okay, so this is a burning point. If anyone wants to write it, if anyone wants to, note of it, it's important, I'd say, because it was in one of the essential readings of the chapter. That is that in the An Introduction to Islamic Law by Halak, the book An Introduction to Islamic Law, authored by Halak, the chapter with the legal schools, right? So it explores the development of Islamic legal schools known as mazhab. So this the concept of mazhab is from that chapter, and their significance in Islamic jurisprudence. The chapter also discusses the emergence of four main school of law, that's the Hanafi, Maliki, Shafi, and Hanbali, and their respective founders and methodologies, right? It also explores the reasons behind the emergence of these schools and the factors that led to their development. The chapter also delves into the differences between the schools in terms of their approach to legal reasoning, sources of law, and the weight given to various types of evidence. The chapter concludes by discussing the continued relevance and the importance of the mazhabs in contemporary Islamic legal discourse today. So this is a small write-up for what the chapter is about. If someone wishes to read it, good, because this will help you in this answer, the sources. I have a lot of material for this chapter from the book itself, but I'll be putting that in the book that I'll make for um, for the ebook. So that's there. Um, well, let's talk about the development of jurisprudential schools. Okay, so just on the note that Islamic law did enter a period of rigidity and inflexibility, and we will actually, and there was also the role of jurists shifted to interpreting rather than, developing the law by ijtihad. So let's start with the development of jurisprudential schools. Let's start with Sunni schools, right? And there are four main Islamic jurisprudential schools that are widely recognized by Muslims today. That is Hanafi, Maliki, Shafi, and Hanbali. The development of these schools can be traced back to the first few centuries of Islamic history, right? Let's start with Hanafi. Hanafi school was founded by Imam Abu Hanafi, that is dated in 767 CE in Kufa, Iraq. Abu Hanafi's methodology focused on rational reasoning, independent thinking, and the use of analogical reasoning, qiyas, to derive legal rulings. And Hanafi became predominant school in the Ottoman Empire and is still followed by many Muslims in the Central Asia, Turkey, and Indian subcontinent, as Pakistan and India, right? So that's Hanafi school of law. Then let's do Maliki. So Maliki school was founded by Imam Malik ibn Anas, dated in 795 CE in Medina, Saudi Arabia. So Malik's methodology was based on the practices and customs of the people of Medina, which he believed were in line with the teachings of the Quran and the Sunnah. So Sunnah is the Holy Prophet, right? And as well as the fact that the Holy Prophet actually lived there for a while. So you do understand why I would think that. Um, so the Maliki school is predominant in North Africa, West Africa, and some parts of Middle East. That's Egypt, some parts of Egypt. So next is Shafi. So the Shafi school was founded by Imam Muhammad ibn Idris al-Shafi. That's dated 820 CE in Mecca, Saudi Arabia. Al-Shafi's methodology emphasized the importance of the Quran and the Sunnah. So his point was that the Quran and the Sunnah are the most important, as well as the consensus, the ijma, and analogy, the qiyas, the four sources, primary and secondary sources, in deriving the legal rulings. Shafi school is predominant in Southeast Asia, including Indonesia and Malaysia. So that's also in some parts of Southeast Asia and Yemen, and also East Africa as well. That's something that I read. Okay. Um, so we have Humbly. The last is Humbly, and that is the school was founded by Imam Ahmad ibn Hanbal, dated at 855 CE in Baghdad, Iraq. Ibn Hanbal's methodology was based on strict adherence to the Quran and the Sunnah without resorting to analogy, chaos, and consensus, right? Ijma. The Hanbali school is predominant in Saudi Arabia and other parts of the Arabian Peninsula. So the point is that there's a difference between the Shafi and the Hanbali. The Shafi does take ijma and qiyas, the consensus and analogy into point, but Hanbali only takes the Quran and the Sunnah, and that's it. So Hanbali is followed in by a minority of Muslims in Saudi Arabia, Qatar, UAE, and some parts of the Muslim world. That's how we can see it. So it's also worth noting that there are also other minor schools of Islamic jurisprudence, but these are the main ones. So let's talk about okay, yeah. So one just came to mind in the minor jurisprudence, Zahiri school. Zahiri was Dawood al-Zahiri in 1883 as well. Let's talk about the Shia school of thought, right? So in Sunnis, um, Shia has several school of thought as mazhabs, right? But they differ in their methodology, sources of law, or the legal reasoning, right? So let's start with Jafri. Or let's start with Isna Ashari. Isna Ashari is a bit, I have a bit, okay. So, Isna Ashari school of thought, also known as the Twelver Shiism, so is a school of thought that is based on the belief that there are 12 divinely appointed imams, starting with Imam Ali, the cousin and the son-in-law of the Holy Prophet, peace be upon him, and ending with Imam Mehdi, which will come, right? So, who is believed to be in articulation um, and will appear at the end of time as a final savior, right? So, Isna Ashari school of thought is largest and most prominent in Shia school of thought, with the majority of Shia Muslims belonging to it. It emphasizes the importance of Al-Bayt, Ahl al-Bayt, the family of the Holy Prophet, peace be upon him, particularly the Imams, as the rightful leaders and the guides of the Muslim community, mainly found in Iraq, Iran, Bahrain, but also sizable minorities. One may not say minorities, but sizable minorities in other countries like Yemen, Lebanon, Pakistan, today in even in the Western world. The Isna Ashari school of thought has its own sources in law and jurisprudence, which include Quran, Sunnah, and the Holy Prophet, and the 12 Imams. Ijma consensus of the scholars. So the scholars would be the Imams and Akal. This is not the ijma. Okay, so this is not the uh, qiyas, but rather the akal, the intellect here. So for Akal, it has its own scholars and jurists who specialize in interpreting and applying these sources of law to contemporary issues and challenges today. The Isna Ashari school of thought has had a significant impact on Islamic intellectual and cultural history, particularly in the fields of theology, jurisprudence, and spirituality. It has also influenced many aspects of Islamic art, literature, and architecture. Isna Ashari believes that there were no further Imams after the 12th Imam that retired from the world in 1874 CE. Overall, the Isna Ashari school of thought is a distinct and important branch of Shia Islam, which has played a significant role in the development and evolution of Islamic thought and practice over centuries. Okay, so next let's talk about Smiley School. So that's the Smiley School is named after Ismail bin Jafar, the seventh Shia Imam, right? And it is the smallest of the Shia schools of thought. The Smiley School is known for its emphasis on the interpretation of Islam and its belief in the continuing presence of the Imam, who is regarded as the spiritual and temporal leader of the community. The Smiley school relies on the Quran, the Sunnah, and the guidance of the Imam as its main source of law. Ismailis have maintained an unbroken chain of Imams from the time of Hazrat Ali down to the present Aga Khan. So, after that, let's talk about Zaydis. So the Zaydi school, that is the named after Zayd ibn Ali, the grandson of the Holy Prophet, peace be upon him, and is the second largest Shia school of thought. The Zaydi school is known for its emphasis on justice and equality. This is all the fifth fivers, the five imams, and it believes that the ruler should also be chosen based on the qualification rather than his lineage. The Zaydi school relies on the Quran and the Sunnah as its main source of law. Overall, the Shia school of thought share many similarities with each other, such as their belief in the importance of the Al-Bayt, the family of the Holy Prophet, peace be upon him, and their emphasis on justice and social equality. However, they also have differences in their approaches to Islamic jurisprudence and its interpretation of Islamic sources. Next, let's talk about modernization of Islamic law. So, by the end of the 3rd century of the Islamic era, the schools of law had crystallized and the law entered a period of rigidity and inflexibility. We've already considered this a bit, right? So, This was the role of jurist now was to interpret the law rather than seeking its development by ijtihad. So many jurists and commentators have argued that the phenomenon of closing the gates of ijtihad had taken place, right? Ibn Khaldun stated that all that remained after the basic text had been produced and the continuity of its transmission had been established was to hand down the respective traditions of the schools and for each individual to adhere to the acts and the traditions that were of their own school of thought, right? The Ottomans were, though, inspired by the West, predominantly the French, and sought to modernize Islamic law. The codes of commercial, maritime, and penal laws were introduced during this time, and these codes were called tanzimiyat. When the Industrial Revolution made the Ottomans feel at a disadvantage, they decided to put aside some of the areas of Sharia and replace them with Western laws stating that the Sharia is only suitable for a perfect world. Although the Ottomans felt able to effect changes in the commercial, maritime, and penal law of the empire, no attempt was made to change the law of family, considered as the very heart of Sharia, right? So, however, in the 1915, reforms took place, and there were two notable, very important firmans. So, firman is FIRMAN, firman. So, these are imperial decrees by the Sultan, issued by the Sultan, right? So, the two were at this time that the many men who were coming to the provinces were coming for work to Turkey, right? To the Ottoman Empire, to Turkey, they were coming for work, for employment. So these men were marrying the local women, and all too often they were leaving these women and going back to their land. And the Turkish wife were being abandoned; they were left behind without being divorced, or they were not given any maintenance, and there was nothing done during this time. So, one of the firman was that under Hanafi law, the official law of the empire, such women were unable to petition to court for a divorce once their marriage had been consummated, right? Nor could a married woman call upon her blood kinsman to support her. And one of the Firman gave the women such a right to seek a judicial decree from the court in accordance with Shafi doctrine. That is, that women were allowed to obtain a court divorce. And the other was that there was another was that they could also obtain a divorce, saying that the husband had gone insane as well. So that happened, so they could take a divorce. Um, Most countries in the Middle East have now enacted laws of personal status, two of the most recent being in UAE law, that is the 2002, and the Qatari law of 2006. So these are the modernization of Islamic law, the modern laws that are being introduced. Moreover, we do know that there is like Muslim family laws, ordinance of 1961, that is like Pakistani and Bangladeshi laws, family laws, and many. Some of the judgment I think I referred in the first lecture or maybe at the start of this lecture. I don't remember now, but that was there. I think it was in the first lecture. And as well as when Kemal Ataturk became the president of Turkey, he summoned the ulama, that were the legal scholars, and asked them to prepare a code. But like I don't think so. That was to prepare code, introduce reforms into the area of family law beyond that were already introduced by like family rights of 1917. The ulama couldn't meet the demands and they couldn't prepare it, but they adopted the 1926 Swiss Civil Code, though with slight like amendments. So that were those codes were like adopted. Again, another country to reference is the Egyptian court, Egypt, of 1949. They were drafted by Abdul Razak Sanhuri. But unlike the Turkish civil court, these courts did not seek secularization but made provision of Sharia as the source of law, and in case of gap of the court itself, provided that this should be filled by reference to the Sharia. So Sanuri himself stated that in drafting the codes, he did not leave out a single sound provision of the Sharia which could have been included. Right? Um, there were furthermore attempts to at a modern Islamic theory, legal theory. So we do know that the first attempt at formulating a modern Islamic legal theory is often traced back to the Egyptian judge and jurist Muhammad Abdu, that was 1849 and 1905. However, it is also considered that he had been preceded by Jamaluddin al-Afghani, and that was in 1838 till 1897, who, in reaction to Western colonial activity in the Muslim world, urged the Muslims to first reform and modernize their laws. Whether the concept of a modern legal Islamic legal theory has succeeded or not is still a subject to debate, right? But there's no doubt that a lot of development has happened, right? And there are new two concepts as well. That's new ishtihad and religious utilitarianism, and religious liberalism, moderation, and balance. So these are some of the key terms that you might want to use in your answers. Okay, so we're now basically coming to an end. So these are some of the sample questions that I have put over here. Let me just put out the 4 questions that are. First is discuss the importance of the Quran as a legal code. Then the second is as a divine law, the Sharia does not change. Third is explain and discuss the validity of the theory of closing of the gates of Ijtihad and opposing views. Fourth, discuss the classification and legal approaches of religious utilitarians and religious liberalists. So let's go one by one. The first question, discuss the importance of the Quran as a legal code. So firstly, I think starting your answer out with the fact that this is basically sources of Islamic law, right? But it focuses on Quran. Quran is a primary source. So you talk about sources a bit, and then you directly go into the question saying that the primary sources, that is the Quran and the Sunnah, and we'll be focusing on the Quran. So you'll be, yes, discussing all the sources slightly, even hadith, that is the second primary source, and then the secondary sources. Um, the other sources will be also examined, and their importance will also be considered. But special mention in the points are noted nearly for all. So the points that you will nearly be referring to will be of the Quran and how the Islamic legal system has been affected by Quran. So I think in the first slide, I mentioned that there are some verses of the Quran that are they directly target the legal system for Islamic law. Some 66 verses, I guess. So they are there, and those are like important. And those are like important verses, and they are the main legal code for Islam, and they are in the Quran. So using those verses, you can, tell how important it is. Then the second is as a divine law, the Sharia does not change. See, this question is more about historical context as well. So a careful discussion of the nature of law in Islam. In addition, there will be a discussion of the problems facing reformers seeking to bring a law which reached its peak of development over 1,000 years ago, but which is still in application into the modern context. Explain how reformers have attempted to effect changes while remaining within a Islamic framework. So basically, um, we have been passed the sources of law have been passed down through generations, and they have not changed. So the code has not changed. Quran is still the same. Hadiths are still the same. We do know that there's Bukhari and Sahih and then Muslim. So talking about all of those laws and codes, we say that it's still the divine law. It still does not change. There is different in interpretation, but there is no change or amendment to the divine law or code itself, right? Explain and discuss the validity of the theory of closing of the gates of Ijtihad. Okay, we've talked a lot about ijtihad. So, but just putting into some pointers. So, this theory has been exposed to challenge, which is true, because the idea of closing of gates of ijtihad in itself says that one may say that ijtihad is still open, and one may say that it's not. Right. So, you should discuss the main theory and idea behind it first. Then like firstly what is ijtihad, and then go into like how people say that the doors of ijtihad are closed, and why would someone say that they are not, and the contrary views to it, and then present your own views as well, because this is explain and discuss, right? So you should actually discuss that. Why do you think that your own views? What do you think? Is it open? Is it closed? Bearing in mind that Islamic law remains virtually unchanged, which is true. That is, the laws are the same until the 19th century. And again in the 19th century, in the Tanzimiyat and all of the reforms and the codes and the laws, they one may say that these are the interpretations. These are codes which have been taken from Sharia, because we just talked about who was it? Uh, we just talked about one of the jurists who kept the Sanuri. So we talked about Sanuri just right now, that he did not leave out a single provision of Sharia, right? So if he could include it, he did not leave it out. So that means that the same Sharia, the same laws, the same legal code has been applicable. It is applied and it is continuing. So it is unchanged, and even these tanzimiyat and the reforms, they are just interpretations and bringing them into codes, so they're easy to use for a modern person, right? And then discuss how the use of ijtihad in various forms has come about in the 20th and 21st century, that is in the modern day today. The fourth question is a good. Okay, so discuss the classification and legal approaches of religious utilitarians and religious liberalists. We've already in the first lecture discussed a lot of things regarding two separate points, like how would a liberalist think, how would a conservative think, how would the old thinkers, the utilitarian would think, how would a liberalist think. So the good answer would start by giving a brief background of what firstly emerged, like why is there like an emergence to these two groups firstly, what led to it, and then you can define that each of the groups, what they do, how they think about it, and what their how are they classified by halak as well. The writer we talked about previously. You can also then discuss and engage in the respective legal approaches in relation to the interpretation and application of Islamic law in the modern times. Also, identify and cite some example of the relevant scholars who have been associated with each of the two groupings, and possibly discuss the significant divergence in their respective approaches. So this is some of the things. that are really important. This brings me to the end of the entire section A. There are other questions as well, so I could just read out some questions because these questions were already done with. So the answers are in the two videos. You can discuss and critically evaluate the role of ijma as a source of Islamic law. So this is a previous question that I saw in the past papers. And similarly, there is another one that's the Quran is the primary source of Islamic law. Discuss. Um, we had to discuss the importance of Quran as a legal code, and now this is the Quran is the primary source of Islamic law. Discuss. Similarly, explain and discuss the contribution of Shafi to the development of the role of usul fiqh for the purposes of law reform. Ijtihad is the most important source of Islamic law. Discuss. One of the questions, and one more, let me read out, is that this one. The closing of the gate of ijtihad is a theory supported and advanced by prominent scholars such as Joseph Sachs, but challenged by others such as Wael Halak. So I have talked about Halak a bit. Joseph Sachs you can actually read on by yourself, so you can write a better answer. I hope these videos have helped you. And if there are any questions, just leave them in the comments below and I can get back to you. So, yeah, advice on answering the questions. I guess the advice is if there is a point of discuss, give your views because that's very important. Have different point of views, different perspectives, different scholars in the notes that you're making. Moreover, do read through verses, ayats, some important hadiths to include, to note in your answers. And yeah, be confident in writing your answers and stick by them. So, best of luck. So, yeah, thank you for your time. And I hope you liked the video. Please share, please subscribe, and please like the video as well. So, and if there are any questions, kindly comment them so I'll get back to you. Thank you.